Now, to speak on the ever-changing landscape of plaintiff legal costs, we have Daragh O'Sullivan, legal cost accountant at Lowe's. A chartered, certified accountant and a legal cost accountant with 15 years experience as managing partner at Lowe's, Daragh advises his clients on all aspects of legal costs. Welcome, Daragh.
So good morning, everybody, or good afternoon, rather. Thank you very much for the very kind invitation to speak here today. We appreciate it. I'm joined here from our firm by Aoife McDonough, whose background is solicitor, and Aoife leads up the opposition team in relation to costs. So in the short time that's available to us, I'll attempt to convey in summary format certain developments in legal costs and outline briefly the opposition and adjudication process. I'll talk about the Legal Service Regulation Act 2015 as it relates to legal costs. And then we'll talk about Section D, which is a component of a bill of costs, tenders and costs, which is a really important aspect as well to remind ourselves of. And then developments in legal costs, particularly inflation, cost trends, initiatives for consideration, and a possible change to scale fees. And then we'll have a discussion thereafter. So, as you know, the process and methodology of adjudication, which was originally taxation of costs, changed arising from a decision in Sheehan v. Core. And that was a Supreme Court case, and that, together with Part 10 of the Legal Services Act 2015, entitled Legal Costs, and contains what might be described as some exceptions as a consolidation of existing statutory provisions relating to legal costs, and the recovery of those costs and the adjudication thereof. And to date, those matters had been governed by what might be described as a confection of statutory enactment going back almost 170 years. And then crafted onto that is Order 99 of the Rules of the Superior Court, and itself amended on many occasions over the years. So you'll be familiar with the methodology for assessing costs in both the Superior Courts and in the Circuit Court. We were reminded that the costs that are being recovered invariably on behalf of the legal team representing the plaintiffs are party and party costs, and as distinct from practitioner and own client. And we remember that party and party costs are always those of the client who ultimately is held responsible for discharging same, the client being under legal liability to discharge such costs. So, and irrespective of whether the client or the opposing party will be pursued to discharge the costs involved, the actual liability for such costs always remains that of the client. Given that the highest percentage of adjudicated costs are party and party, and that is most relevant to why we're here today, we'll concentrate on that. It's worth noting as well that a reasonably small percentage only end up proceeding to adjudication, although this percentage is rising, particularly in circuit court areas where costs have been trending upward at a level that we would be comfortable with. Tendering in the High Court has been very effective, and that was only introduced as part of the Legal Services Act. And it certainly puts plaintiffs to the pin of their collar if a competitive tender is made. So, what does a legal cost adjudicator do, and what does a county registrar do when a bill of costs is presented to them? So there's a number of things, and it's up there on the screen. Firstly, they have to examine the nature and the extent of the work. They have to verify that that work was done in the first instance, and that in the circumstances of this case, that it was reasonable for a charge to be incurred. And having done all of that, then they establish what a reasonable charge might be. And you'll be familiar then with the factors that they take into account, which are set out on the screen. And among those are the complexity and novelty, the skill, specialised knowledge, time and labour, urgency, place and circumstances, number, importance and complexity of the documents involved and the values involved, and whether there was costs of experts involved as well. And only then would it be appropriate to apply a charge. Now, that's done with some rigour in the cost adjudicator's office, and it's also done by the county registrars as well, and we'll come on to that momentarily. So a decision then is made in respect of the professional fee applying this methodology, but it also applies to those fees claimed by counsel and witnesses as well. So, but the only caveat there is that apart from costs being reasonably incurred in respect of professional fees of solicitors, they must be necessarily and reasonably incurred in respect of counsel and barristers. So that sets the test somewhat little higher. So in the High Court, if people aren't happy with the decision, they have the right to consideration, or what used to be referred to as objections. They can file a consideration with the costs adjudicator. Interestingly, that goes back before the same cost adjudicator, unless there's some sort of an obvious or material change presented. The decisions don't alter so much, but they do alter. And whilst it might seem somewhat strange that it would go back to the same cost adjudicator, I've been the subject and involved in a number of considerations where the decision has changed. And so I wouldn't have too much negative to say about the High Court aspect. In terms then of further onward appeal, there's the right of a party to appeal to the High Court, and that's under Section 161 of that Act as well. So the same provisions apply to the county registrars, and that's under Section 141 of the 2015 Act. So their obligations are to have regard to the same principles as I've just set out there on the screen. And each county registrar is also obliged to maintain a register of determinations, and it's maintained. Now, as we know, the county registrar it's a wide and varying role. And it was envisaged at one stage that perhaps they might report into the Office of the Legal Cost Adjudicator, and it did make an appearance in the draft bill. However, it didn't make it into the final bill, which I think is somewhat unfortunate because there is a lack of uniformity throughout the country. And I would say that there's probably a lack of appropriate accountability for the county registers in respect of costs. And my preference would be that they would report into the Office of the Legal Cost Adjudicator, so that data and information would be available in one area to examine the performances of the county registrars throughout the country of Ireland. And I think that would be helpful. However, that is a suggestion, and I think it's something that should probably be considered. The other thing that made its way in the Legal Services Act was Section D. And up until its enactment, it wasn't possible for a plaintiff solicitor to recover the costs of work done post the final order. As you now know, that's now there, and it had a material impact on costs that the defendants and your clients, the insurance companies, had to pay as a result of that. And there was a lot of talk after it arrived, and it wasn't sure whether it would apply to county registrars, and it did, and it does, and significant fees ranging from anywhere from probably 1,500 up to 30,000 are being allowed on bills of cost. That wasn't there. It's a new chunk of costs that the defendant, usually the insurance companies, must now carry, and it's something that is being pursued, and it's there, and there's not much getting away from it. The only way to mitigate it is to resolve the bill of costs in early course, and that does have an impact on reducing that fee clearly. Tendering in High Court, we heard mention here of game changing and game changers, and I would. It's an obvious one. It wasn't there, but it made its way in the 2015 Act. it does resolve matters. Interestingly, plaintiffs, if a competitive tender is made, they back off. Over 90% of them will accept it, and they will accept it even though it isn't the figure that might adjudicate, and that's subjective too, as you know. But it can be lower, up to maybe 10%, and it's still not enough for them to say we'll proceed. Some of them do, and if they proceed and don't defeat the tender, there is a significant impact, and that includes duty of 8%. It does include costs of the legal cost accountant opposing the bill, and it also excludes the costs from the date of tender up to the date of adjudication. So it's a material sum, and our experience is that it shouldn't be a ridiculous tender, and they do float around, and it's easy to decline them. You don't have to consider them for too long. But if it is one that hits the spot, savings can be achieved for your client together with putting the matter to bed and at an earlier stage. So the next thing I want to talk about is cost trends. And as you will appreciate, over the last number of years, there have been a significant challenge in relation to costs and how they have developed. And legal costs in particular, from probably about 2018 to 2024, based on our experience, increased in the order of between 10 and 15% per annum, with one exception, and that was 2021, when they certainly increased by at least 20%. And that was taken into account the effects of Section D in 2021 and its impact. So inevitably, that it must be a concern for the pocket, the paying parties, and it is. It's also an issue as well, I would think, and part of and just to go back a step, in 2011, when the world economically was in dire straits, costs did reduce somewhat. Maybe in the order of 30-35%, and remained probably static then, from then up to 2018, when there was a new vision of where legal costs might go. There was also, during that time, and work that you would have all been involved, there was a reduction in damages, or certainly work commencing on that. And what we saw was the matters were beginning to settle at an earlier stage. So the average cost of a claim didn't rise at the levels of inflation that I'm referring to now. So the slide that we're looking at here now is based on data that we have maintained over a number of years now. So for all cases, to the extent that we can, and I say that in compliance or not offending any GDPR, we record outcomes, and we record amounts that were claimed. So if you look at this slide for the Circuit Court, and I have one for the High Court as well, in 2018, you can see that the costs as a percentage of damage in the sum claimed was 64%. And ultimately what was allowed either through negotiation or through adjudication was 45%. Fast forward then to 2024, and you can see that the sums claimed were 104% of the damages. And ultimately, at the running total that we have year to date, or earlier in the summer, let's say August, is 77%. So from 2018 to 2024, it has gone from 45% of the damages up to 77% of the damages, which if there's only one spotlight, it's certainly, you would have to be looking at the top line there, 2024. And just to complete the picture, let us look at the High Court then as well. So the High Court hasn't been so materially different. However, the trend is in a certain direction. And 2018, it was 30% of the damages, and 2024, it is 38%, which, based on the presentation that I've given in the earlier slides, setting out what the inflation was, running at least 10%, perhaps 15%, and maybe 20% in 2021. That doesn't fit in entirely, but the fact is damages have reduced, stages of settlement have come forward, and the High Court has been better at managing these costs, I would say, than the Circuit Court. And now we're seeing greater volume hitting the Circuit Court. So if there's a strategic piece here, and there's a piece where focus is required. But if you were starting off and you were in a hurry, you would say, let's look at the Circuit Court. So moving on then, and I'm conscious that this is a wider discussion, so these are more suggestions and are possible initiatives, and maybe planting a seed as to how costs can be reduced and managed. The costs can be managed in two ways. Firstly, before the order issues, so that's down to the defence teams. So actions of the defence teams may result in them having to pay certain costs, higher costs, at some stage in the future, right? So you will be well aware of that, but it's useful to maybe reflect on that and consider that. And then there's costs post-order, where you're at the mercy of the legal cost adjudicator and the personality that goes with that, and the county registrars, of which there are a number of them throughout the island, or throughout the jurisdiction of Ireland. So if we deal with the pre-order costs, tender of costs, my suggestion would be that in all circumstances there should be a tender, and it shouldn't be a ridiculous tender. It should be where the market is. The defence strategy is something that I think is important as well. How many times has the cost adjudicator said to me, Mr. O'Sullivan, you delivered a full fence, you can't come in here and say you didn't mean it. And but often that's what transpires in these cases. And I know there'll be a host of reasons, and I'm only looking at it from a cost perspective. But how litigation is approached does have an impact on costs. Stage of settlement is one that I'll demonstrate to you now, that it does have a big impact on costs. And of course it would, because if a matter is settled shortly after proceedings issue, or if a matter settles by a determination or a judgment of the court, you're going, for the same sum, you're going to have two very significant amounts of costs. And if I can just fast forward and look at that slide, based on the data that we have built up over a number of years, if you look at a hearing, clearly the costs will be 100% at hearing. If you settle the matter prior to hearing and you don't have witnesses in attendance and so forth, well then you're down to 78%. Move backwards to post-notice of trial, pre-notice of trial, pre-defence, pre-proceedings, well then you can be at 29%. So that would fit with if you were to guess, or certainly if you were put to the pin of your collar and said, give me an indication. So that looks okay. And then where it's up for grabs is the number of cases. So a lot of cases, the majority, no, not the majority, the highest percentage, 41%, settle at a pre-hearing stage. So they're at an advanced stage and they settle. Clearly, if that could be brought back to pre-defence, well then, there's significant changes to be achieved there. So that's something to consider. It's something that, because my background is in management information, I've tracked this on behalf of my clients for many years now, and I've seen improvements in that regard, particularly where they focus on it, and they can KPI their panel solicitors in that regard, and examine and compare on a regular basis. The other thing is cost differential. How many times have we seen cases issue in the High Court that settle for Circuit Court costs? There's clearly, there may be reasons. Sometimes there aren't reasons, good ones anyway, as to why they issued in the High Court. And So it would be important that that would be considered, A, that under no circumstances they would get High Court costs, and B, maybe that they would be remitted back to the Circuit Court, and similarly a District Court as well. A lot of claims that come our way, for whatever reason, and I'm not criticising anybody, I'm just telling you what my experience is based on the facts, is that cases settle for District Court damages but seem to attract Circuit Court costs. I mentioned regime change there. I don't mean to upset anybody really, but there is. I do think the reporting structure for the county registrars should be examined. I think the county registrars, and they will tell you, their remit is wide, and you'd be well familiar with that. And then very often tagged on to their list at the end of the day is the really important matter of costs. And focus rightly is on the Circuit Court now. The volume of cases that are being presented to the county registrars is rising considerably. Often the level of training for the county registrars is nil, are very close to it, and they're expected to be expert on legal costs, when in actual fact they may know not a lot about legal costs. That is an issue. And all of a sudden you see a compounding of decisions and the effects of earlier decisions and errors in there being repeated, because all of a sudden we're back to comparators, which really have no place in the assessment of costs. They're just simply a useful sense check. And the assessment of costs, based on my experience before the taxing masters and the adjudicators, is quite an involved process. And in order to give a case its proper chance, and for both sides to have the appropriate time to make their case, and for an adjudicator to be given time to consider it, that all takes time. And wrapping up a 50,000 personal injury case in 15, 20 minutes is not good enough, actually, when you look at the level of costs involved and what's at stake, and when you look back at the comparators. So I think that the importance of the county registrars perhaps reporting directly to the Office of the Legal Cost Adjudicator, training, or the entire cost process being brought in under the Legal Cost Adjudicator's office is something that could be considered. And it certainly would lead to a more streamlined, a more orderly, consistent approach to the way costs are being resolved. Many of you here have said to me over the last number of months that decisions are somewhat strange, perhaps, in how they have been arrived, because they're just simply too high. We've all had these examples where you pitch a matter at a certain fee and you go in there and it could be double it. Now, we're not out by double. We can often be wrong by 20%, but we're not wrong by 100%. And on it goes from there. So I think there's a good bit in there that is worth considering, and I'll talk to anybody in relation to that and how that can be improved to the satisfaction of everybody, actually. And then, of course, the other mention is the material information and the targets. And the devil is in the detail. And what we have found from our experience is that, and you will have seen this as well, if information is maintained in a proper format, it can be used in any format, and it can be used to drive targets and to drive panel and to emphasize where there are issues and to make really good decisions. The next one then is to look at scale costs if all of that doesn't work, and bring costs into a proper level. And that's something that has been mentioned to me on a number of occasions. And there's certainly an appetite for that in certain areas, and there's of course there's going to be an absolute entrenched opposition to it in other areas. And it's a discussion that probably should be had, and to allow people to arrive at where they consider to be the best system for dealing with costs. You have predictability, you have transparency, it's efficient, it's potentially fair, and then you have access to justice. And against that, you have inflexibility, and you have quality v costs, and you have disparities, and you have limitations, and you have overhead costs varying throughout the nation. They're just 5 of each that I wrote down. If I was told to go away and do a paper on it, we could be here a long time on it, because we need to go into each of those. You know, fairness could be in favour and it could be against as a factor. You know all this, but I think my own view is that scale, if all else fails. But there are improvements in the existing system that can be made, and I've touched on a few of those there, to bring costs back into a more appropriate level relative to the level of damages being one of the factors that exists. So there you have it. In summary then, the Legal Services Act, there was a lot of excitement in the run-up to it, but from a legal cost perspective, Part 10, and in particular sections 150 and 151, didn't bring about a whole lot of changes. It sounds eerily familiar to what we had for the last 170 years, but it did bring it together, so we're grateful for that. And it has modernised and codified the system. The Adjudicator's Office is running well, I would say that, and the costs get dealt with very efficiently and I would say fairly in the Cost Adjudicator's Office. However, costs in the Circuit Court have risen disproportionately, as I've set out, and more so in certain circuits, and that's not right, that certain circuits would have higher costs than others, apart from maybe where they would have exceptional overheads in a particular circuit, but I've never heard that mentioned. Costs are tackled prior to an order and post an order, and I think that's important, that if I could ask you to note or remember that there's 2 aspects to this. When a bill arrives at the Cost Adjudicator's Office, there's only so much that can be done to it at that stage. The real quantum of the bill is determined during the course of the proceedings, and ultimately then the market will value it, as they say. And then the post-order procedures is something that the conversation should start, as it already has, and I'm happy to answer any questions that you may have, so thank you very much.
I'm sure you'll. Thank you for such an insightful overview, Daragh. We'll open it up for a few questions now.
Thank you, Daragh. It's Sarah from Cedric here. I just do have a question in relation to the cost trends and the percentages and numbers that you put up. At what stage was the conclusion of those cases where you determined those numbers? Did they run or?
These are cases that where proceedings were issued. So it excluded any cases that settled prior to the issuing of proceedings. Because why do I say that? We don't become involved in matters where proceedings haven't issued.
Oh, no, I understand that. It just, did the case run to conclusion? Like, did it go to trial? Did it? Or was there?
It would have, all cases commenced and they would have settled or concluded at various stages throughout the course of the proceedings.
Okay, that's great. And I did have one other question. Typically in a, let's say a circuit court case where we've received an authorization from the Injuries Board after an award has been declined by the claimant, and there's an early settlement after that, roughly what kind of costs would be typical to pay a solicitor? The early stages, say proceedings have just issued, there's no need for nomination, and a deal has been done.
I don't know the answer, Sarah, because like there is no typical answer, and I'm not being evasive when I say that. I have to be fair. So I can't throw a figure at you. I don't know whether it's 5,000 or 9,000 as I stand here. I genuinely do not know. So it depends on what's going on, and it's based on what work did they do, and where are they based, and and what are the circumstances of the accident, and what investigations occurred, what reports were considered. So I don't know. But it evidently should be considerably lower than where a matter would be if it went to hearing, and the truth, based on our experience, is that different circuit courts have different views on that, but not so many of them have actually run in the circuit courts, because there's very often no order available to run those. So it's a little bit open-ended. I can't answer it until I see particular circumstances.
No worries. Okay, thank you very much.
Thanks, Sarah.
Hi, Daragh. Thank you for the presentation. Just, I suppose, point of clarification for me, and apologies if you did sort of say this in your words, but when you're saying you're seeing the rise in the costs, is it the professional fee of the plaintiff solicitor, or is it the total bill of costs that you're seeing? And if it's the total bill, where do you see the big rises within the bill? Is it the additional counsel's costs, or is it experts' costs, or where do you really see the rises are coming through?
The stats that we have presented here are based on the total costs. As you know, the professional fee invariably is one of the larger components of the total bill of costs, and it has probably increased, I would say, significantly along the lines that I have mentioned to you. All the others have increased as well, particularly the counsel's fees and to an extent witnesses. To a good extent witnesses, because you will see certain reports that might have recovered at €750 in 2018 or 17 are now up to €1,500 all day long, and that's 100% of an increase. But proportionately, the professional fee has the greatest impact on the total rise in costs. So it has been across a number of the categories, and the professional fee being an important part of that.
I think we could possibly have a full conference on this and have a full question answered. But look, for now, I think we'll have to call it. But again, thank you very much, Daragh. I really appreciate your time, and thank you very much.
Thank you.